the other motions and amendments listed on the selection paper. I call the Minister to move the motion to disagree with Lord's Amendment 1.
Thank you, Mr. Deputy Speaker, and I beg to move that this House disagrees with Lord's Amendment number 1. This bill is vital to stopping the boats and preventing the dangerous, illegal and unnecessary journeys across the Channel. The bill, as passed by this House, made it unambiguously clear to illegal migrants and people smugglers alike that if you come to this country by unlawful means, you won't be able to stay. Instead, you'll be detained and swiftly removed, either to your home country or to a safe third country. The government brought forward a number of amendments in the Lords to enhance the bill. These are largely of a technical nature, so I won't detain the House by setting these out now, and instead will confine my remarks to the non-government amendments passed by the other place. Mr. Deputy Speaker, I'm grateful to the House of Lords for undertaking its proper role as a revising chamber. Some of the changes made by the other place are, however, little short of wrecking amendments, and not one that the government can support. There are a few honourable exceptions, and I'll deal with those first, but I'll happily give way to the honourable gentleman.
I'm very grateful to the Minister for giving way. As he says, most of the amendments we are going to be debating and voting on later today are wrecking amendments. Does he agree with me that none of these amendments address the fundamental need to address the actual incentives for people to cross the Channel? That's what the bill does, and these amendments take that away.
Well, my honourable friend is absolutely right, and I would direct members on either side of the House to the speech made in the other place by the noble Lord Clerk, in which he said very powerfully that as a former Home Secretary and long-standing member of this House, interested and knowledgeable in this issue, he sat through many hours of debate and didn't hear from any of the critics of this bill a single credible alternative to the government's approach. And if you follow that logic, you need to get behind the government then and support it to deliver this approach. I will give way in a second. He also made the other point, which I agree with, that if we fail to tackle this issue, if we dismiss the concerns of members of the public, then we will see very serious consequences in the years ahead in terms of a fragmentation of community cohesion and a weakening of the successful multi-ethnic democracy that all of us on all sides of this House are proud of and want to see sustained for future generations. I'll give way to the Honourable Lady as she asked first.
I thank the Minister for giving way. The Minister says that in the other place has put forward record amendments. Is it not true that the other place has really put through amendments that ensures that we honour treaties and we respect our judiciary and we ensure that the Home Office is acting within the law?
I don't agree with that. There are a few important exceptions, and I'm going to come on to that in a moment. So I hope that in the remarks that I set out and in answering any question, I'll come to the Honourable Lady, I'll be able to reassure her that on the points of substance made by those who want to see this bill proceed and this issue be tackled, that the government is making the right changes to the legislation. I'll happily give way to the Honourable Lady.
Very grateful to him for giving way. He says that no one has proposed a credible alternative, but there are three Lords' amendments which do. Amendment 102, a duty to establish safe and legal routes. Lords' Amendment 103, which would amend Section 1 of the Crime and Courts Act to confer on the National Crime Agency specific functions of tackling cross-channel organised crime, and Amendments 104 and 107, which would mean that the government had to set up a 10-year strategy on refugees and human trafficking, working with foreign governments. Do these four amendments not constitute a credible alternative?
As it happens, I'm going to come on to each of those points in my speech. So if the Honourable Lady doesn't mind, I'll refer to those in a moment. But in each case, we are already doing what the Honourable Lady asks us to do, The bill already has a specific provision with respect to safe and legal routes, and when we had this debate in this House previously, we agreed further to set out the details of that. And with respect to the National Crime Agency, well, the officers in that agency who work on organised immigration crime, who I've met in recent weeks in Belgium, in France, in Italy, in Tunisia and in Libya, will be very surprised to hear that the agency doesn't have the authority to act on organised immigration crime, because those, in some cases, very brave men and women are doing that work every single day on our behalf already.
I totally agree with everything you said, Gareth MacDonald. Totally agree. Yeah, absolutely spot on.
Let me make a small amount of progress and then I'll give way to the Honourable Lady. Can I turn to the first issue of substance, which is Lord's Amendment 2, which provides that the duty to make arrangements for removal applied to persons who entered illegally from the date of commencement of Clause 2, rather than on or after the 7th of March 2023, as originally provided for in the bill. We acknowledge the position advanced by some in the other place, and indeed in this House, about the retrospective effect of the bill. But these Lord's amendments do go too far in resetting the clock. The closer we get to commencement of the bill, the greater the risk that organised criminals and people smugglers will seek to exploit this, and we will see an increase in crossings as the deadline looms, which only puts more people at risk. To guard against this, I'll finish the point, then come to other members. To guard against this, we brought forward amendments in lieu, which moves the application of the duty from the 7th of March to the date of royal assent. The 7th of March date would, however, continue to apply for the purpose of the Secretary of State's power to provide accommodation for unaccompanied children and for the purposes of the bans on re-entry, settlement and citizenship. This government amendment in lieu has a particular advantage with respect to the concerns expressed by my right honourable friends from Maidenhead and Chingford with regard to modern slavery, but I'll come on to that in particular in a moment. I'll give way to the Honourable Lady as she asked.
Grateful to the Minister for giving way. I wonder if you could tell me how many Afghan women have been able to avail themselves of the ACRS Phase 3 programme. That is the government's position around a safe and legal route. And as we understand it from various debates that we have had in Westminster Hall, we're looking at a handful of Phase 3. Everything else refers to what's happened in 2021. If I could draw his attention as well to the recent horrific drownings off Greece, where there were a number of Afghan nationals who were included in those, but also in Pakistan-administered Kashmir. What really is the point of these ineffective, supposed safe routes?
Good. Hello, Andrew. Luke. Don't worry, you've not missed much. I've just basically started, so welcome aboard and good to see you.
Well, the Honourable Lady and I share the same objective, which is to ensure that the schemes that the government has already established are operationalised as quickly as possible. And so those people who are eligible, perhaps including the women that she is in contact with, can come to the United Kingdom, settle here and find sanctuary. It's incredibly important that the UK is a beacon in the world for resettlement schemes. We have already supported over 20,000 people under ARAP and ACRS to come to the United Kingdom. I appreciate the point that she makes, that the numbers in recent months have been lower than she or we would like. One of the reasons for that is because there is so little capacity today in the UK to properly house individuals. And one of the explanations for that, I will give way to Emily, one of the explanations for that is that the sheer number of individuals entering the country illegally on small boats has placed an intolerable pressure on our social housing, on the contingency accommodation that we have available. And if we were to bring further individuals, which we want to and are continuing to do, to the UK, they risk being housed in hotels, which is an unacceptable way to house vulnerable people, and in particular families. I'll give way to the Honourable Lady.
It is time. We have, in terms of the APPG for Afghan women and girls, we have hundreds of civilians who would like to have a Homes for Afghans scheme. These people are waiting and have already volunteered. This is a scheme ready and is equivalent to the Homes for Ukraine. So I really would urge the government to take us up on this and make sure that these supposed safe routes are actual safe routes.
Well, I strongly endorse the comments that the Honourable Lady has made. The Homes for Ukraine scheme has been a superb one, which we should all be proud of. I took part in it myself at one point. If it's possible to create a comparable scheme for Afghans, that's something that we should consider. And I know that my right honourable friend, the Levelling Up Secretary, who has responsibility for that, is considering that. With regard to the broader point about resettlement, the UK has a very strong record in this regard. Of course, we would all like to go further, but since 2015 we have welcomed 550,000 people to this country on humanitarian grounds, mostly on resettlement schemes, and we're one of the world's leading countries for those schemes. I'll give way, if I may, to the right honourable gentleman if he still wishes to.
But while we're on the question of dates, I would like to ask the Minister if he has any idea as to when the Supreme Court may be considering and concluding its judgment, because
Who dressed Bill Cash this morning or this afternoon?
it does have relevance not only to the question of the progress of the bill, but also in relation to the question of Parliament Act, in case it were to be needed.
Well, it's a matter for the court itself to determine, in the first instance, if it intends to take up the appeal and then at what time it will be heard. I can only point my honourable friend to the final paragraph in the summary judgment from the Court of Appeal, which expressed the view of the three judges at that point that this is a matter of great urgency and needs to be handled expeditiously. So I would hope that the Supreme Court, if it chooses to hear our appeal, does so swiftly, but that is a matter for the Supreme Court itself. I'll give way to the Honourable and then I should make some progress.
I'm very grateful to the Minister, and he will know that I had a difficult approach to this bill from his perspective at second reading. When he embarked on addressing Lord's Amendment 2, he did so by saying, "I'll now address the first Lord's Amendment of substance." Yet Lord's Amendment 1 deals with our international obligations. And I think we did have that curious start where this bill couldn't even have a full declaration on the front of it about compatibility with some of those international obligations. So I just say to the Minister, I think it would be incredibly helpful for him, and perhaps it was just a turn of phrase, to not only address Lord's Amendment 1 and the government's approach to international legal obligations, but to outline exactly what is contained within Lord's Amendment 1 that the government takes issue with.
I am actually going to come back to that issue later in my remarks, but let me be clear, if further reassurance were required, that the government takes its international law obligations extremely seriously, and we believe that all the matters outlined in this bill are within our international legal obligations and will, should it or any aspect of the bill be legally challenged, contest that vigorously to defend the position that we've set out. I would just point him to one important element of the recent judgment in the Court of Appeal, which was the question as to whether a state such as the United Kingdom could use another state, enter into a partnership such as we have with Rwanda for the purposes of asylum, whether that would be compatible with the Refugee Convention, and point out that all three of the judges agreed that it was compatible with the Refugee Convention. So on arguably the central international law issue at stake, the Court of Appeal was very clear that the approach of the government is compatible with international law.
I'm just going to disappear for 5 minutes.
To the Minister for giving way.
You carry on
he's made that commitment about the Refugee Convention, but the Lords did say in their amendment that this bill should be read so as not to conflict with the European Convention on Human Rights, on the Refugee Convention, statelessness and the rights of the child, and anti-trafficking conventions. Why is the government so opposed to that clarification and that clear statement on the face of the bill, if we are the beacon and the adherent to international obligations and law.
Because it's not a normal practice to state that on the face of a bill. It goes without saying that the government obeys its international law obligations as it does with respect to all pieces of legislation. I am going to make some progress because I really appreciate this is a relatively short debate, if the Honourable Lady doesn't mind. There are other questions I need to address. If I can turn to the issue of detention, which I know has attracted a great deal of interest on both sides of this House, as indeed it did in the other place. It is a necessary part of the scheme provided for in the bill that the duty on the Home Secretary to make arrangements for removal is accompanied by strong detention powers. We know from experience that once a person is released from detention, the prospects of being able to effect removal are significantly reduced because they typically abscond. This is why the bill restricts but doesn't exclude judicial challenges within the first 28 days of detention, so that illegal migrants can be processed and removed rather than simply absconding on arrival. These powers cover family groups as others so as not to provide a perverse incentive for people smugglers and migrants to co-opt unaccompanied children into bogus family groups to avoid detention, putting children at risk in the process. The Lords Amendments 31 and 35 to 38 seek to restore the existing 24-hour limit on the detention of unaccompanied children and the 72-hour limit on the detention of pregnant women. I recognise that there are particular sensitivities around the detention of these cohorts, an issue we debated at some length during the earlier proceedings in this House. Recognising the health concerns around the detention of pregnant women and the particular vulnerability of unaccompanied children, we brought forward amendments in lieu which maintain the existing 72-hour limit, extendable up to a week with ministerial authorisation, on the detention of pregnant women, and enable the first-tier tribunal to consider granting immigration bail after 8 days for unaccompanied children, rather than the 28 days provided for in the bill. With respect to pregnant women, I know a number of members of this House, I know a number of members of this House spoke out on this issue, but I'd like to pay particular tribute to my friend the noble Baroness Sugg for campaigning in the other place. I'll give way to the Honourable Lady.
I thank the Minister for giving way. My right honourable friend knows firsthand the impact on Dover and Kent on our services, on schools and other important local services of this issue.
Another one of the loans.
With the proposed continuation of special measures for unaccompanied young people and now pregnant women, will he confirm that he will be meeting and discussing the impact of these proposals with me and Kent colleagues, particularly bearing in mind the poor state of our local maternity services and the incredible pressure that is already being placed on our communities?
That's 13 years of Tory austerity for you. That's what's caused that.
Well, I'd be pleased to meet with my honourable friend, as I have done in the past. She knows that I've met on a number of occasions with local authority leaders in Kent and want to do everything I can to support them. Historically, they have borne a very high burden as a result of their location adjacent to the points of entry, and that has placed some public services in Kent under a great deal of pressure. We have created, in the last 12 months, the national scheme to ensure that unaccompanied children are moved across the country and that all local authorities play an equitable part in supporting them. We've also provided substantial financial incentives to local authorities to help them to play their fair part. I do appreciate that nothing is ever as simple as that, and developing further capacity with respect to local authority children's homes or foster carers takes time. But I hope that the measures we've put in place already will make a noticeable difference. Prior to the recent seasonal increase in individuals crossing the Channel, we had success.
Sorry for butting in, but yeah, oh look, the P&O lady's been through the Thatcher's wardrobe again. That's funny.
We managed to clear all of the UASC hotels that the Home Office had utilised, and I hope that we can keep reliance upon them to an absolute minimum this summer and autumn. In the case of unaccompanied children, the change I've just described will apply where an unaccompanied child is detained for the purpose of removal and aligns with the 8-day period for making a suspensive claim. I will in a moment. This approach will ensure that we can continue to detain a person who we suspect to be an adult but who claims to be a child pending the outcome of an age assessment. Good wait on, gentlemen.
The Minister for giving way again, but it's important, I think, for the Chamber to note that this isn't really a concession. It's not even a time limit on detention of children. It's the ability to apply for bail, as I understand it, after 8 days. So you have to be aware of your rights and you have to have access to the ability to challenge detention. And it also only applies to a very small cohort of children. The vast majority of children detained under this Act will not have access to that process altogether.
Well said.
I think respectfully that the Honourable has misunderstood what we're proposing. If a child arrives unaccompanied in the United Kingdom, who is a genuine child and not subject to age assessment, they will be swiftly processed. They will then be sent out into the local authority care system as quickly as possible until they turn 18. We will seek to remove unaccompanied children in two circumstances, as I set out when we last debated this in the House, where we, the Home Office, manage to reunite them with parents in other countries, as we do in a small number of cases today, and secondly, where we, the Home Office, manage to return them to their home country, which is a safe country, and in most cases into the care of social services immediately upon arrival. Again, that happens already today in a small number of cases. So there's no intention to change present practice. We are taking the power, if required, to detain a young person in that situation for up to 8 days to be housed in age-appropriate accommodation to enable us to make that removal effective. If I can give way in the first instance to my right honourable friend.
It's Stuart C. MacDonald, Gareth MacDonald, yes. Yes, that's his name, Stuart C. MacDonald. What a good guys. Quite like him. All-round good egg.
I'd like to thank my right honourable friend, and I'm listening very closely to what he's saying. I'm particularly thinking about arrivals as well as leavers. Can my right honourable confirm that children who are clearly children will be placed in child-appropriate accommodation, and that all those who may or may not be children will have appropriate safeguarding? And if that is the case, when will we see that in writing?
I'm grateful for my right honourable friend's interest in the bill. She and I come at this from exactly the same concern to protect unaccompanied children. Any genuine child who comes into the United Kingdom will, as I say, be swiftly taken into the local authority care system, which she's very familiar with thanks to her former work as a children's minister. To the extent that that child is in the detained estate, they will only be housed in age-appropriate accommodation. And I'll come in a moment to set out how that age-appropriate accommodation is determined in law today. I'll give way one more time to the right hand.
So just to dig deeper into what he's suggested, he has suggested that a child on arrival may be detained, which is not currently the case, but if that happened, that would be in child-appropriate accommodation.
That's correct, but today the law is that a child can be detained for 8 days for the purpose of examination. That is not routinely done by the Home Office. Today, a child is detained for 24 hours or less. They are only detained, whether that were for 24 hours or indeed if the Home Office chose to make use of the power of 8 days, in age-appropriate accommodation. And it would be unlawful to house an under 18 in accommodation which did not meet the standard set out in law, and I'll come on in a moment to describe what that standard is. I'll give way to my right honourable friend.
I'm just waiting for the moment when somebody brings up these murals.
Immensely grateful to my right honourable for giving way and for all the work he's done on this bill and on these amendments. He will understand that the matters he's now discussing bring into sharp focus the issue of age verification, which I, as he knows, tabled an amendment on which the government ultimately represented as an amendment of their own. Can he confirm that age verification measures will be obligatory and comprehensive to ensure that we don't get the nonsense of people pretending to be children in order to game the system any longer?
My right honourable friend is right. We do take the issue of age assessment extremely seriously. As he knows, there are some young adults, or indeed not so young adults, as I understand the oldest individual that we've encountered who posed as a child was subsequently found to be 41 years of age. There are
What, you cannot tell the difference between a child and a 41-year-old adult? Wow. Surely you must be able to know.
Are individuals who abuse the system. That's wrong as a matter of principle, but it's also a serious safeguarding risk to genuine children and to all of those caring people who are involved in supporting children, whether that be foster carers, teachers, members of the general public. And so we have to take this issue seriously. That's why the bill does retain the power to detain an individual who is subject to age assessment for up to 28 days. During that period, the Home Office or local authorities would conduct age assessment. Today that's done through the Merton system, which is proving to be a system that takes longer than we would like, but which we want to be conducted within 28 days. We are now taking advantage of the powers that we took within the Nationality and Borders Act to begin to roll out scientific forms of age assessment. That's going to happen over the course of this year. That will initially happen concurrently with the Merton assessment, and we want to ensure that that is demonstrated to be robust and we can make that system as swift as possible. And I hope that members on all sides of the House will unite in our common agreement that it is important that we weed out those cases of abuse because it poses such a risk. And I'm afraid we've seen some very, very tragic instances, such as the murder that occurred in Bournemouth at the behest of somebody who had posed as a child, and the state has to do everything in its power to prevent that happening again. If I may make some more progress, I'll happily come to the Honourable Gentleman, but I wanted to conclude the point that I was making with the Right Honourable Lady with respect to the detention periods and the standard of accommodation, because I know this is an important point. I can assure the Honourable Lady, and indeed my friend, the member for East Worthing and Shoreham, who has also taken an interest in this, that we will seek to detain unaccompanied children for the shortest possible period. Where there is no dispute that someone is under 18, they will, as quickly as possible, be transferred to the local authority accommodation estate. Where there is a doubt that a person is indeed under 18, as they claim to be, they'll be treated as a child while an age assessment is undertaken. Such a person will be detained in age-appropriate accommodation as the law already provides. This is set out in the Detention Centre Rules 2001, made under Section 153 of the Immigration and Asylum Act 1999. Rule 11 of the 2001 rules provides that detained persons under the age of 18 and families will be provided with accommodation suitable to their needs. If no such accommodation is available, they will not be detained and will instead be transferred to a local authority as soon as possible. I hope this provides my right honourable friend with the assurance that she's been seeking, but I'll happily give way to my honourable friend from Worthing if he wanted to intervene. He does.
I'm grateful to the Minister because he keeps quoting the Detention Centre Rules 2001, which are of course 22 years old. Clause 11, which he's just quoted, is detained persons aged under 18 and families will be provided with accommodation suitable to their needs. So then there's a checklist of about 65 things, virtually all of which are about fabric, about freedom to practice religion, access to personal hygiene. Which of those contains support services relevant and age-appropriate to children?
Well, the rules are related to 2001, as he says, but they have been updated, as I understand it, since then. They've also been tested on a number of occasions in the courts, and the Home Office takes very seriously our responsibility to live up to them. It would be unlawful if we were to accommodate an under 18 inappropriately. If I can read out the other limbs of the Rule 11 that he described.
How many glasses does Tim Loughton need?
Which is under the Families and Minors section. Detained family members shall be entitled to enjoy family life at the detention centre, save to the extent necessary in the interest of security and safety. Secondly, detained persons aged under 18 and families will be provided with accommodation suitable to their needs. And thirdly, everything reasonably necessary for detained persons' protection, safety and well-being, and the maintenance and care of infants and children shall be provided. That, I think, is a comprehensive set of principles. It's one that has stood the test of time over the last 22 years. If it needed to be strengthened, then of course we would do so. But I hope that the honourable gentleman will take my strong assurance from the dispatch box that that's the standard of accommodation that we intend to house anyone who is a minor in. And if that accommodation is not available, then we wouldn't house those individuals in detained accommodation at all. I'll give way one last time.
And I will elaborate on this if I'm lucky enough to catch the eye of the Deputy Speaker. Where in those 65 sections does it mention relevant child-appropriate support services like social workers, child psychologists and others that will be necessary? Nothing of which he has described guarantees that children will be in age-appropriate accommodation that has age-appropriate care, which is the point.
Well, I'm happy to write to the honourable gentleman detailing all of the support that would be available. But the point that I'm making is that this is the existing law. This is the law that has existed for more than 20 years. So nothing in this bill changes that framework. The Home Office will rely upon the existing framework that has been in place throughout the years, including when the honourable gentleman was the Children's Minister and was considered satisfactory throughout that period. I'll give way to the honourable gentleman.
I appreciate the Minister for giving way. I'd also like to congratulate him on everything he's doing on this issue, especially in relation to unaccompanied minors. But can I ask him, is he convinced that everything he's doing will not create a perverse incentive where evil people smugglers push unaccompanied minors onto boats across the English Channel, and then of course when they're here they're able to bring their family over, etc. Is he convinced that we'll do everything we can to stop that perverse incentive?
There's another one of the Tory lunatics, Peterborough MP. What an absolute bell tap he is.
Well, I think the changes that we're proposing here, contained in the government amendment in lieu, strike the right balance, whereby we preserve the intention of the scheme that lies at the heart of this bill, but do provide some further protections for minors. He's right to make the broader point that more substantial changes to this bill, such as those envisaged by some members of the other place, will, I'm afraid, undermine the very purpose of the bill. And in considering each and every one of these amendments, we have to ensure that we don't drive a coach and horses through the core deterrent effect that we're trying to achieve here. And why do we want that deterrent effect? Because we don't want to see anyone, whether that be an adult or a child, crossing the channel in small boats, placing themselves in danger, placing themselves under the support and control of people smugglers and human traffickers. We have to keep in mind the original purpose of the bill and ensure we don't do anything that undermines that.
Well, if you want to stop the boats, then processing plant in France would be a perfect plan.
Give way to the right honourable gentleman.
Could he just, on age-appropriate accommodation and family life, could he just explain why it appears that he felt that the murals on the wall at the Kent intake unit acted to damage the deterrent effect of which he has just spoken. And in that context, if parents are going to be able to continue to have family life with their children for the period of time that they are detained, for example, will there be any chance of them having access to picture books to enable them to read to their children?
Oh, this will be an interesting answer then, won't it?
The Right Honourable Member has been to any of these facilities, but we provide very high quality facilities for families and for children upon immediate arrival in the UK. And I've made it a particular focus to ensure that we support those individuals appropriately, ensuring that the conditions in those places are decent and compassionate at all times. The cohort of unaccompanied children last year who passed through the location that he describes were largely teenagers, and we didn't feel that the site was age appropriate, but it does contain a range of support for children and infants, including all the things that he's described, and nothing about the decoration of sites changes the fundamentals that if someone comes to the United Kingdom, we'll treat them with decency and compassion at all times. Give way to the Right Honourable Member.
Thank you, Mr. for giving way. I just want him to be fairly explicit with regard to the type of detention centre we're talking about. So, for example, will children, either unaccompanied or with their parents, be detained in detention centres like Harmersworth and Colnbrook? As we agreed on a cross-party basis, they should never again be detained in those centres.
Good one there, Douglas 92. Such high quality that children get kidnapped. Very true.
I know that the Right Honourable is particularly knowledgeable on this issue because he represents immigration removal centres. It is not the government's intention that families or minors would be housed in those settings. Minors and families will be housed in age-appropriate accommodation, which is entirely separate and different in nature to the immigration removal centres that he represents. There are facilities like that today. There's not a large number of them. As part of the operationalisation of the bill, we will need to invest in further facilities and ensure that they meet the standards set out in the detention rules that I've just described. But I hope that gives him some reassurance. I will give way, then I really must make progress or else other members won't have an opportunity.
I'd like to thank him for giving way again, and I know that just there's a huge amount of concern about how this is going to be implemented. Of course, we thought that hotels would only ever be temporary, and yet they seem to have carried on. Can you be really clear? When a child comes in, he said that they will be moved into local authority care as soon as possible. What is the maximum amount of time that a child could be waiting before they are in that local authority care under this bill?
So
the position today is that a child arrives in the United Kingdom and then is immediately processed in an age-appropriate setting. We then seek to place them with local authorities. It is only if local authority care is not immediately available that we then deploy the Home Office UASC hotels. There have been instances, such as last year, where young people were waiting in those hotels for a period of days. That is not our intention, but the only limiting factor is the availability of local authority care to support them. If more local authorities were able to come forward, and as I said earlier, it's not simple because they have their own capacity constraints, then we wouldn't use those hotels at all. It is not our intention to detain minors for a long period for examination. We want to flow them straight out into local authority care, as is the right thing to do. I'll happily give way.
Thank the Immigration Minister for giving way. He's obviously being pressed on the nature of the kind of accommodation or detention that children and young people will be held in. But the spirit behind the Minister's intention does matter. So therefore, can he explain, Is it true that he gave orders to the Asylum Reception Centre to paint over children's cartoons? And if so, why? Because nobody believes that Mickey Mouse cartoons either encourage or deter boats to arrive, and they simply think that this is the minister actually not showing some common decency towards vulnerable children.
I've been...
This will be an interesting answer then. No doubt it'll be just as mealy-mouthed as the one he gave to Hilary Benn, won't it?
Clear in answer to her right honourable friend that we provide very high quality care at all of the centres in which we support unaccompanied children. We didn't think that the setup in that particular unit was age appropriate because the majority of those individuals who were unaccompanied passing through it last year were teenagers. That does not change the fundamentals that we support anyone who comes to this country with decency and compassion. And I'm afraid that the right honourable lady is missing the point that this bill seeks to reduce the number of unaccompanied minors coming to the United Kingdom precisely because we want to protect them and ensure that they're not victims of people smugglers and human traffickers. And I take at face value her support for those individuals, but if she wanted to reduce this trade, she would support this bill or come forward with a credible alternative, and she hasn't come forward with a credible alternative. And so her compassion is to a degree performative because she doesn't come forward with alternatives that would genuinely support individuals.
You want to protect children by painting over murals to make sure that they feel less welcome. What an idiot.
Let me move on to the other issue that I wanted to cover, which is that regarding modern slavery. I know the provisions in the bill relating to this have been a particular concern to my right honourable friends, the members for Maidenhead and Chingford and Woodford Green. And I welcome the opportunity that I've had in recent days to discuss with them the Lord's amendments on this issue. It remains our view that there are clear opportunities to misuse modern slavery protections, and it is therefore essential that we take steps in this bill to prevent misuse. The NRM referral rate for people arriving in the UK on small boats and being detained for return has risen from 6% for detentions ending in 2019 to 73% in 2021. I'll finish this paragraph, I'll certainly come to my right honourable friend. The referral rate has since fallen slightly to 65% for detentions ending between January and September. The increase in NRM referrals, 33% from 2021 to 2022, has put the NRM under serious strain, and that is only getting worse as the trends increase in one direction. There is significant and increasing pressure on public services, and that's why we want to take action. Be pleased to give way.
I'm grateful to my right honourable friend for giving way and for the discussions that we have had recently. He knows that I have a problem with the statistics. He has yet again quoted the statistics that the Minister in the other place quoted as well, that the rate at which gives the implication that the percentage of people coming on small boats and claiming modern slavery has risen from 6% to 73%. It did not. What he is talking about is people who are subsequently detained for removal. The average number, will he now confirm that the average percentage of people coming on small boats and claiming modern slavery has not changed over the last 3 years and is around 7%?
I think that my right honourable friend and I agree on this point, which is that the point at which individuals misuse the NRM is the point at which the state is trying to remove them from the country. And what our concern is that there is a significant increase in the number of people misusing the NRM and the good work that my right honourable friend has done on this issue to bring about a spurious, frivolous, last-minute...
That face, she didn't look impressed, did she? Just thinking, what an idiot you are.
...way of frustrating their removal from the country. And so the statistics that I've referred to are the most relevant statistics, because this is the point at which individuals are in the detained estate for the purpose of removal, Their removal from the United Kingdom is imminent, and what we are seeing is a very high proportion of them are using the NRM to try to delay that removal. Delay, as she knows from her great experience, is particularly relevant because once someone has delayed their removal, they are liable then to be bailed, to go back out into the community. Some will be very difficult to bring back into the detained estate or may abscond and never be seen again. And so even under the current system, this makes it extremely difficult to remove people. Under the scheme envisaged by this bill, we will be seeking to remove many of those people to a safe third country such as Rwanda. Whilst today we are predominantly removing people back home to their own countries, like Albania or Romania. And so the incentive to misuse the NRM will be significantly higher, and it's reasonable to assume that a very large number of individuals will make use of this as a route to frustrate the scheme. And that, as I said earlier, does risk driving a coach and horses through the purpose of the bill, which is a swift and speedy form of removal, acting as a deterrent to prevent people making the crossing in the first place.
There are two elements really here. The first is in answer to that. The answer is, first of all, the whole system can be massively speeded up, which is a fact of the NRM straight away. That is an obligation that was meant to be given in the last bill but was never brought into the guidance. But the main point here is nothing that has happened outside of the UK can be evidenced in this particular point. So we're talking about here his fear that people are actually departing into the UK and then subsequently claiming this. Now, the real problem right now in the bill, and he knows I have concerns about, is that much of the prosecution process against the traffickers takes place because of the evidence given by those who have been trafficked. Right now, the bill suddenly at report changed dramatically the presumption, and it did it without any notice. In other words, it's a presumption that they don't need to be here at all, other than that there is some evidence that somehow they do, whereas before it was that to get that evidence they do. And that's the point he knows. The point I wondered about why we're knocking out this amendment rather than amending it and specifying what are the categories that are exempt. The real point here is he runs the risk now of people not giving evidence, not cooperating with the police, and us not getting prosecutions. Because if they're going to be cleared out of the UK whilst giving evidence, and this is the point, then the reality for them is they'll stop because they're in danger of being picked up by the traffickers again outside. So I wonder if you'll really rethink this to actually use something on the face of the bill to define those that are exempted within this category.
Firstly, can I say I'm grateful to my right honourable friend for the advice and the wise counsel he's given me, and indeed my right honourable friend, the member for Maidenhead. We have sought to make changes and to listen to their point of view, and that's why we brought forward two significant changes. One, as I've already outlined, with respect to retrospection, which means that the cohort of individuals who entered the United Kingdom from the 7th of March to royal assent, who have not been in the detained estate and are then, if you like, in the community at large, in many cases living within the supported accommodation, and are in some cases liable to exploitation by human traffickers and other criminals. Those individuals will now not be included in the full extent of the bill's provisions, and so can be supported in the ways that he wishes. That has significantly reduced the pool of individuals that he was concerned about. We've also, and I'll come on to say this in a moment, we're also committing to bring forward statutory guidance, which I hope will provide further reassurance, in particular on the question of how law enforcement authorities would interact with victims of modern slavery to ensure they can be appropriately supported and have the time that they need to recover and to bring forward their claims so that we can all achieve our shared objective, which is that human traffickers get prosecuted. I'll give way to the right honourable gentleman.
I'm grateful to the Minister. I do recognise that he's moved in some measure on these issues, and I'm grateful for that. But can I return to the point about the statutory guidance? Because surely, given that we all accept that you will only deal with the organised criminals that run modern slavery with the cooperation of their victims, surely we can't be proceeding with the clause as it currently stands without knowing what the statutory guidance is going to be. If it was well known that this was going to be an issue, I'm surprised, Frank, that the draft of that statutory guidance hasn't been available to us today. That might well have reassured us sufficiently to support the Minister in his contention. As it is, that's still left hanging in the air. When are we going to see that statutory guidance? Not the first time.
Well, let me answer his questions by setting out what will be contained in the statutory guidance. The operation of the exception for potential victims of modern slavery to remain in the United Kingdom for the purpose of cooperating with a law enforcement agency in connection with the investigation of a trafficking offence will be subject to statutory guidance. The guidance will provide that an individual who has arrived in the UK illegally and has a positive reasonable grounds decision based on an incident that has taken place in the UK will be afforded 30 days from this positive decision to confirm that they will cooperate with an investigation in relation to their exploitation. They will not be removed within this period, which accords them with the protections that are equivalent with those set out in ECAT. Should they continue to cooperate with such an investigation, they will continue to be entitled to the support and protections of the NRM, and should further time, in addition to the 30 days, be required, then that period is extendable to ensure that the police and indeed the victim have the time that's necessary to ensure that traffickers are brought to justice. I hope that answers his question. I appreciate his desire to see the letter of the statutory guidance, and I'll take that away. But that is the essence of it, the position that mirrors the provisions of ECAT. I'll give way.
When will that come into force? Surely we have to have that in force before the provisions of the bill come into force. Can he give us that assurance and confirmation?
Yeah, it is our intention that the statutory guidance will be provided and be in place for commencement of the bill. And I hope that also answers the question that the Right Honourable Gentleman had, that he feels that previous assurances in prior legislation weren't fully delivered.
Well, can I just say that obviously I welcome some of the moves that the government's made, and I support the principles of what the bill is trying to do. This is, though, I think, a really significant problem of the government cutting off its nose to spite its face. What we have is a positive when they give evidence, and a prosecution that takes place that cuts down the likelihood that people will be allowed to traffic boats across. So it turns round and contradicts the purpose of the bill. Now, the point I made to him earlier on,
clearly in Dunkin' Donuts, got his lunch on his finger,
was that the sudden change to the presumption power of the Secretary of State is really where the problem arises. And surely the way to deal with that is not through the guidance mechanism, but to actually make sure on the face of the bill that that presumption is restricted and clearly restricted. His problem, when he says these are the intentions of guidance, on the other bill that came in December, I was given that assurance as well. There has never been any guidance that emerged subsequently as a result. So he'll forgive me, having sat in government myself, don't always take the word of the government absolutely as a categorical assurance. The only way we can get this is by doing something on the face of the bill. This amendment, as amended, would really help enormously to reassure people, but achieve the objective of what the government is after, which is more prosecutions, fewer boats.
I understand the position of my right honourable friend, but I hope that he will accept that we intend to bring forward the statutory guidance and that it will set out the points that I've just described. I'd say they do accord with ECAT. I appreciate that there are those who would like a longer period than 30 days, but that seems a reasonable place to settle, given that is what the framers of ECAT themselves chose as a period for recovery and for bringing forward claims. I therefore commend... I'll give way one last time. I have been speaking probably too long.
I'm very grateful to the Minister for giving
way
yet again. I'm just a little confused, and I hope he can help me. He says that the government wants to bring forward this guidance, yet it is opposing Lord's Amendment 57. Lord's Amendment 57, as I read it, would confer a power on the Secretary of State by regulations to make provision about the circumstances in which it is necessary for a person to be present in the UK to provide cooperation of the kind mentioned earlier in the clause. That is precisely the guidance that he's now saying he's going to bring in. So why is he opposing Lord's Amendment 57?
We don't need that power to bring forward statutory guidance, and so, although well-meaning, it is superfluous, because we have the power already to bring forward the statutory guidance. It was our intention to do so. It is being drafted, and it will set out the issues I've detailed already. On the legal proceedings questions, and I'm conscious, Mr. Deputy Speaker, that I need to draw my remarks to a close so that others can have the opportunity to speak. Lord's Amendments 1, 7, 90 and 93 are, in the Government's view, wrecking amendments, pure and simple. For this bill to succeed, we have to break the cycle of late, repeated, spurious legal challenges, and these amendments would perpetuate those. Lord's Amendment 1, in particular, removes the clear purpose of the bill set out in Clause 1, which is to prevent and to deter illegal migration, taking a wrecking ball to our well-established constitutional arrangements whereby we treat international law as separate to our domestic law. This amendment would incorporate the Refugee Convention, the UN Convention on the Rights of the Child, and other conventions into domestic law by the back door, tying this bill up in legal knots and ensuring that every removal will be subject to endless litigation in the courts. These I won't give way if the right one appreciates it. I just feel I have to make progress now. These amendments are all the more necessary as the bill already affords adequate protections against removal to a country which is unsafe for a particular person. This brings me to Lord's Amendment 23 about the removal of LGBT people to certain countries. Let me say unambiguously that we treat the safety of LGBT people with the utmost seriousness and want to do nothing that would in any way compromise their safety and security. I regret to say, therefore, that this amendment, however clearly well-intentioned, misunderstands the approach taken in the bill. With the exception of EU and EEA nationals and those of Switzerland and Albania, a national of any other country won't be returned to their home country if they make a protection claim. Where they are issued with a third country removal notice, they will be able to challenge their removal to the specified country on the basis that they would face a serious or a real risk of serious and irreversible harm, including on the basis that they would face persecution. If a serious harm suspensive claim is refused, they will have an avenue of appeal to the upper tribunal. So the concerns, as I say, well meant, that underpin this amendment are, in the government's opinion, unfounded. We take, I will give way to somebody, we take pride in the UK's support for LGBT communities globally, and our commitment to this cause is unwavering.
Rwanda has no laws against discrimination against same-sex attracted people and people who have a different gender identity from their sex at birth. Can the Minister not understand why an LGBT person might rather come to the UK for asylum, where we do have such anti-discrimination laws, rather than being sent somewhere like Rwanda where we don't?
I do understand the point that the Honourable Lady is making. I'd say two things in response. Firstly, the premise of asylum being handled in safe third countries is that those countries must be safe. And that is the work that we've done through our partnership with the government of Rwanda, ensuring that appropriate safeguards are put in place, and which has subsequently been tested by the courts and remains an ongoing matter for the courts. The second thing I would say is that we specifically placed within the scheme the safeguard of an individual being able to make a claim that their removal to that country would mean that they faced a real risk of serious and irreversible harm, and that includes persecution. And so, for that reason, I don't think that the instance that the Honourable Lady raises, and I completely understand why she would say this and the legitimate concern that she voices, I don't think that that is founded in reality. And if it were, we would take that very seriously indeed, because there's nothing that this government would want to do to compromise the safety and security of LGBT people. To provide further reassurance, in response to Lord's Amendments 73 and 74 about the power to amend the meaning of serious and irreversible harm, we brought forward an amendment in lieu to ensure that the power can't be used to remove the examples of harm that constitute serious and irreversible harm set out in clause 38.
I think she does, GC. I think she does.
Turning to Lord's Amendments 8 and 9, these undermine a key plank of the bill, that asylum and relevant human rights claims are declared inadmissible. Lord's Amendment 8 would incentivise people smugglers to prioritise unaccompanied children, putting more young lives at risk and splitting more families apart. Amendment 9 would simply afford illegal entrants yet another opportunity to play the system and drag things out as long as possible in the hope that they become eligible for asylum. Lord's Amendment 50 seeks to limit the Secretary's power to transfer a child out of local authority accommodation and into accommodation provided or arranged by the Secretary of State, by providing that they may only do so where it is necessary to safeguard and promote the welfare of the child. Again, this amendment is unnecessary and duplicates existing law. It's already the case under Section 55 of the Borders, Citizenship and Immigration Act 2009 that the Home Secretary is required to have regard to the need to safeguard and to promote the welfare of the child when making a decision to exercise the vice versa power. Moving on to safe and legal routes, Lord's Amendment 102 relates to clause 59, which requires the Home Secretary, within 6 months of royal assent, to prepare and publish a report on the safe and legal routes.
I'm going to give him another 10 minutes at the most, and then I'm going to call it quits, because I'll be soon going for my dinner. So, but I'm going to give him another 10 minutes tops.
By which persons may enter the UK, including any proposed additional safe and legal routes. Lord's Amendments 102 would in effect mandate that such additional safe and legal routes are brought into being within 2 months of the publication of the Clause 59 report. This amendment is again unnecessary. As I set out at report stage in April, we will implement any proposed new routes as soon as practicable and in any event by the end of 2024. I will be fine.
I'm very grateful to him, and I listened very carefully to everything he said on this. I know.
Watch the video at 6 o'clock, John Callaghan. Already on it.
That his intention is sincere, and that we agree about the need for a quota when it comes to safe and legal routes. But will he accept from me that 18 months hence is an inordinately long time, bearing in mind the coming into force of these provisions? And sure, whilst we might not be able to have a complete synchronicity with the coming into force of this important bill, can we at least have a sense, much more of a sense of urgency when it comes to the timescale, and bring forward those proposals for safe and legal routes to a time much earlier than the end of next year?
Quite right.
Well, I know that my right friend and I share our concern on this issue. We want to bring forward any new routes as soon as practical. He has my assurance and that of the government that we'll move as quickly as we possibly can. I don't think that it's practicable that new routes could be brought into being within 2 months of the publication of the report that's envisaged in clause 59. It does inevitably take time to work with partners, be that the UNHCR or others, to develop a credible scheme and to implement it. And it's important that we give the Home Office the time that's necessary. But I've been very clear that we'll move as quickly as possible. Well, the Right Honourable Lady says from a sedentary position that we've had 13 years. Actually, more humanitarian visas were issued last year by this Conservative government than any prior government, probably since the Second World War. Since 2015, under a majority Conservative government, 550,000 people have entered the UK for humanitarian grounds, which compares extremely favourably with the record of the government that she was a member of.
Oh, I'm thinking about doing a few more of these, Gareth McDonald. I'm thinking of doing, because I don't, but it's just fitting them in. That's all. But I'll plan on doing some more.
I will give way. Then I will need to bring my remarks to a close.
Explain to the House, further to the point that has just been made. The government has said it is committed to bringing forward safe and legal routes, but its current position is it's not going to do that until it's stopped the boats. Does he not recognise that one thing that the government could do that would help to stop the boats is to bring forward safe and legal routes.
No, I don't agree with the right honourable gentleman. I think there is a role for safe and legal routes, and I want the UK to be a country that is respected internationally for the way in which we support those seeking sanctuary. That's what we've done in recent years by creating world-leading schemes like that for Ukraine, for Syria, for Hong Kong, and indeed the global scheme that is operated by the UNHCR. I don't believe the argument that I think he's advancing, that if we produce a larger, safe and legal route to the United Kingdom, that will lead to a reduction in the number of individuals crossing illegally in small boats. The individuals that the UK would likely bring to the United Kingdom under a safe and legal route are quite different from those in the main who are coming across in small boats. Most of our small boat arrivals are young men in their 20s and 30s who are already in a place of safety in France with a fully functioning asylum system. The kind of scheme that the government envisages for safe and legal routes is one where we take families and vulnerable people directly from conflict zones or from refugee camps elsewhere in the world. That is a very different system to offering a safe and legal route to predominantly young men in a place of safety to come to the United Kingdom. But that doesn't denude the value of having safe and legal routes, but it's a different purpose. Can I address now the Lord's Amendment 103, which relates to the functions of the National Crime Agency?
I'm going to leave it here because I can't, because I've got to finish up soon. So, but I didn't think it'd waffle on as long as this. I thought surely it's going to be 40 minutes tops, and then didn't think it'd be over an hour. I only plan to be about an hour because I've got things to do. But I will definitely be doing a few more of these, and sometime in the afternoon I'll get a time sorted and get it all organised and let you know in advance so we can all watch it together. So, but I'm gonna have to go. Thank you all for joining, and you guys have cracked me up in the comment section. Proper helped me through this hour of listening to Honest Bob. Good God. Can you imagine him at a party? Jesus Christ. I bet the night would just fly by. But anyway, I'm gonna go. But I'll definitely do a few more live streams, definitely. Ray Bentos and chips. Oh, those were the days, John Callan. Oh, steak and kiddly. Ooh. But I'll definitely do a few more because I enjoy doing these, but it's just fitting them in and having the time. But anyway, gotta go. Thanks for joining me, and you've made the afternoon quite fun. And have a good day. And like I say, I will plan a few more. And I'll get them all planned better instead of just doing them off the hoof like I just did here. So, Bob only attends work events, yeah. But anyway, yeah. Yeah, I will do. Yeah, we'll do more. But definitely. And I'll have it planned as well. So anyway, I'm going to love you and leave you. Thank you for joining. And really appreciate it. And take care. Have a good evening. Have a good afternoon and have a good evening. And